Dear viewers, welcome back to the second episode of our Bangladesh Labour Act training. This training will be conducted in 3 episodes. This is the second one. Today we will see, and the third episode will come in future. So stay with us. Now I'm going to start the second episode today. First one, the condition of employment. We have 72 slides in this lecture, so you have to be very patient. Classification of workers. There are lots of types of workers we can see. First one is casual, then permanent, temporary, substitute, apprentice, probationary, and seasonal. First one is the apprentice. Chapter 18 shall apply to such establishment which is in operation for more than 2 years and in which not less than 50 workers are ordinarily employed. A worker may be called an apprentice if he is employed in an establishment as a trainee and paid allowances during the period of his training. Apprentiable occupation means such trade or occupation in an establishment as the competent authority may from time to time declare by notification in the official gazette to be an apprentiable trade for the purposes of chapter 18. Competent authority means the chief inspector or an officer authorized by him. Apprenticeship allowance. First year of apprenticeship, 50% of entire wages for skilled workers employed and in equal grade of the relevant trade. Second year of apprenticeship, 60% of entire wages for skilled workers employed in equal grade of the relevant trade. Third year of apprenticeship, 75% of entire wages for skilled workers employed in equal grade of the relevant trade. Now substitute, casual and probationary. A worker may be called a substitute if he is employed in an establishment in the post of a permanent worker or of a probationary for the period of his temporary absence. Number 2. A worker may be called a casual worker if he is employed on an ad hoc basis in the establishment for work of a casual nature. Number 3. A worker may be called a probationary if he is employed for the time being in an establishment in a permanent post and the period of his probation is not ended. So, the probationary period can be for unskilled workers 3 months, skilled worker 3 months, and clerical workers 6 months. Now comes the seasonal worker. A worker may be called a seasonal worker if he is employed in an establishment for seasonal works during any work season or remain in employment up to the end of that season. In the case the employment of workers in any industry like sugar mills, chatals, and etc., and in seasonal works, the workers employed therein in the previous year shall be given preference. Seasonal factories, the government may by notification in the official gazette declare any factory in which manufacturing process is ordinarily carried on for not more than 180 days in a year and cannot be operated except during a particular season or at times dependent on the irregular action of natural forces. To be seasonal factory for the purpose of this act. Temporary and permanent worker. A worker may be called a temporary worker if he is employed in any establishment for a work which is essentially of temporary nature and is likely to be finished within a limited period. A worker may be called a permanent worker if he is employed in any establishment on a permanent basis or if he has completed the period of his provision satisfactorily in the establishment. Each owner will formulate the organogram with the service rules for his or her firm, and it should be approved by the Inspector General, and the class, number and type of the workers will be mentioned in the organogram. Contractual. Any authority may, if it thinks fit, employ later on a retiring worker under contract. Agricultural worker means a person who is employed in agricultural work for wages on the basis of daily, monthly or yearly contract, or on a contract of doing any specific work. At the beginning of admission of the apprenticeship, the owner and apprentice shall enter an agreement between themselves as per Form 70. The consideration or object of an agreement is lawful unless it is forbidden by law. All forms of forced labor are prohibited, and any contravention of the provision shall be offence punishable and in accordance with the law. Appointment letter. No employer shall employ any worker without giving such worker an appointment letter. Any person working in any firm can only once be given the letter of appointment. If the letter of appointment of any worker is lost, lost or damaged, the photocopy kept in his personal document or true copy can be supplied subject to the application of the worker. Identity card. Every employed worker shall be provided with an identity card with his photograph. Each owner will provide identity card with the photograph to each worker working in his firm at the cost of the owner. If the identity card of the worker is lost, the fresh identity card can be issued subject to the payment of Taka 50. The information regarding the letter of appointment, identity card and service should be kept as per Form 6. Thank you so much, and this is the end of the second part. We will see you in the third and the final part in our next episode, and we have completed total 19 slides of this Bangladesh Labour Act. In total 53 slides left. So the third part will be the largest one, and stay with us for the third and the last and the largest part of this training, so that you can implement your knowledge to your workplace. happy working in HR. Thank you.